Hi, I'm Greg Dell with attorneys Dell and Schaefer, and today I'm here with attorney Rachel Alters, and we're going to discuss Reliance Standard disability insurance claims. Most of the Reliance Standard disability insurance claims we handle are long-term disability claims. Right. And this video is designed to be an overview talk about Reliance because we have videos discussing appeals and lawsuits against them. But what are your general views about Reliance as a disability insurance company in terms of the ranks of the 40+ disability insurance companies that are out there?
I find that Reliance Standard probably ranks one of the highest on the list of not wanting to pay benefits, looking for any reason not to pay. They will fight the claims. They don't want to approve them in the first place. And then even if they approve them, a lot of times they don't pay for very long, and then they'll cut the benefit off, and then the claimant has to go do an appeal. And then when they just really do not want to pay, they will fight it tooth and nail.
You seem very passionate about their lack of desire to want to pay.
Never.
Where do you see their basis comes more often than not that they don't want to pay? Like, what's their reasoning behind that?
Well, they usually just come up with the same standard reasoning, is that, they believe that even if your physician is supporting your claim, saying that you're unable to do the material substantial duties of your occupation due to the fact that you have, restrictions and limitations, whether it's a back issue or whether it's somebody who has MS or whatever it may be, they just say that the medical records aren't sufficient and there's not enough objective proof to support your physician's opinion, and their own peer review physicians have reviewed all of your records, and it's their professional opinion that you're fine and you can work and you can sit at a desk 40 hours a week if that's what your job entails, or you can do a light duty job or a medium duty job if you're a nurse. They just find every reason whatsoever to disagree with the claimant's treating physicians, even if that physician's been treating that claimant for 10+ years. So they don't care.
Do you find that they rely on their own doctors or nurses, or do they use third-party companies or outside doctors to evaluate a potential claimant?
In my experience, most of the time, Reliance Standard relies on their in-house peer review doctors to do paper reviews, because that's probably the cheapest way for them to deny a claim, because once they send a claimant out for an IME, that costs money. They have to pay for transportation. Functional capacity evaluations can be costly. So usually they start with their peer review and see if they can get away with that. When we get involved, sometimes during an appeal process, they will send a claimant for an IME, an outside doctor, to do an examination who's apparently not supposed to be biased and do a fair examination of the claimant, when they never do that, because in my opinion, they're paid to give an opinion that they're fine and they could go back to work. So it kind of goes both ways.
In terms of Reliance Standard as a company and fighting aggressively, especially when it comes to lawsuits and litigation, they have a long history of many lawsuits that have been filed against them.
Sure.
And then taking it a step further, they often appeal their decisions, especially if, obviously if they lose a case, they'll appeal them as well. And there's many Federal Circuit Court opinions that have been shaped around Reliance Standard cases. And what's interesting about that is that while they're a big company, they often tend to go to one or two of the same defense law firms, and right. Those particular lawyers and law firms have shaped the culture and the view of Reliance, because Reliance feels confident in their defense attorneys to battle these cases, and whether they're going to make good law or bad law, Reliance is going to continue to push forward. And that's unfortunate that they have more of a culture of let's fight than try to take care of the policyholders and try to make more reasonable offers. Because right. When it comes to settlement offers from Reliance, their offers tend to be, I would say, when you talk about the gamut of all the companies, they tend to be really towards the bottom in terms of where their offers are going to be. Now, we tend to pride ourselves on getting some of the highest offers that any claimant's going to get anyhow, just because of our experience of battling them for so many years, that they know that we're going to be able to do as good a job as possible right. to go up against what they have. And that's important, because if your lawyer doesn't handle these types of claims and hasn't handled thousands of disability appeals and lawsuits, then they don't have the expertise and the experience to know what's going on when prosecuting these types of claims. So right. That's a huge advantage in terms of when working with us and going up against Reliance. What is your biggest view when Reliance denies an appeal? What do you think is the most important thing that you have to do for a claimant to help them win their claim against Reliance?
Well, it's extremely important because normally when Reliance denies the appeal, they're going to deny it based on the fact that their doctors disagree with the claimant's doctors. So it's really important to get the claimant's doctors on board, whether that's getting them on the phone and having a phone conference with them, or just making sure the claimant goes in for multiple follow-up examinations and that they're very clear about what their restrictions are, what's bothering them, that their doctors are documenting everything. Because a lot of times the doctors, they don't know that they have to put everything down in the record, and if it's not in the record, it doesn't exist.
Right.
So we need to make sure that that happens. Also, we tend to, we can hire our own specialists to do an independent medical evaluation of our client, to have an outside evaluation and an outside medical opinion about the claimant's ability to work. That can be done in a functional capacity evaluation or sending them to a medical doctor. So those are a couple of the things that we can do to make sure that we have the most objective proof to support an appeal. And at the end of the day, if the appeal is not overturned, that also is objective proof that a judge will see in court to help them win their case when it comes to the federal case that's filed in court later on.
So, of course, when it comes to after you've done an appeal, and if you lose the appeal, you have to file a lawsuit in federal court because 99% of the Reliance Standard disability policies are governed by ERISA.
Right.
And when you get into court, Reliance's view on the case is going to vary based upon whether or not they have an arbitrary and capricious standard of review or if they have a de novo standard of review. And we have a lot of videos where we discuss the challenges of an ERISA lawsuit, which I encourage you to watch those videos. But a de novo review is really the best thing for a claimant. Unfortunately, all of the Reliance Standard policies, for the most part, have a discretionary clause in them. And this discretionary clause says that they have the right to interpret the terms of the policy and make the claim decision on the policy. And by doing that, that means that the judge has to apply an arbitrary and capricious clause. When it's arbitrary and capricious, the judge has to say, look, if Reliance acted reasonably and reached a reasonable conclusion, then we have to deny your claim. I have to uphold the denial of your claim. But if there isn't that provision, this discretionary clause in your policy, then the judge can say, I'm reviewing it on my own, fresh with all of the evidence, and if I find that you're disabled, then that's the ruling that I'm going to make.
Right.
So some states don't allow for discretionary clauses, and if you're in one of those states, we'll evaluate that, and then we'll get the de novo review no matter what, and the settlement offer for your case will be significantly higher, and the chances of winning will be much higher. But if you have arbitrary and capricious, we have to review every element of your case and make a determination as to whether or not we can prove that Reliance acted unreasonably.
Right.
And that is basically a reasonable person standard, and it can be very challenging, but it's something that we've had a lot of success at doing.
Yeah, we do have a lot of success at winning those, but the issue is, a judge could look at one reasonable basis as just being them hiring the appropriate peer review physician to review the records, and if that physician is in the proper specialty and gives an opinion that the claimant is fine, the judge can view that as the one reasonable basis to deny the claim, and unfortunately that's really hard to get around.
So, I want claimants to know these cases are winnable, but you have to be realistic about the challenges that are out there, and we're one of the few law firms that's going to be straight up with you from the beginning and let you know from our experience to say, look, yes, we think we can win, no, we don't think we can win, but here's what we think the case is worth. Here's the real dollar amount we think we're going to get from you, because we know when you've resolved hundreds of these cases with these companies, you know how much you're going to get offered, and there's no reason to string you along and not allow you to plan for your future when we know with pretty good certainty within $10,000 or $15,000 where the number is going to be. And we're never low. If anything, it's going to go high. So we're going to tell you up front what's going on, and I think you're going to be able to plan appropriately. You're probably not going to like where the potential offer is going to come, but you're going to get the facts as to what you need to know. So overall, what you should take from this video is Reliance is a very challenging company. If you're considering applying, you should dot all your I's, cross all your T's. We help with the application process. We offer you a free consultation to review your policy. If you've been denied and you need to appeal or file a lawsuit, feel free to call Rachel or any of the other attorneys in our firm. We can help you no matter where you live in the country. We make the process very simple, whereas everything's done via email or fax and scanning. We'll offer you a free immediate phone consultation, and we look forward to the opportunity to speak with you.